Hi, and welcome to the CIArb PolicyCast, where we explore some of the most pressing issues in the world of dispute resolution as they stand today. In this episode of the PolicyCast, we will be talking about the legal and the logistical challenges of keeping up with the ever-growing demand of quick delivery at a low cost. In conversation with my eminent guest today, we will be attempting to explore the implications of COVID-19 on the way maritime disputes are managed and resolved, and we'll take a look at how ADR can become a key strategy to this end. And my guest today is Karina Albers. And Karina, if you don't know, although you should, is a maritime arbitrator and commercial disputes mediator in London, Hamburg, and Singapore. She is an aspiring full member of the LMAA, a member of the German Maritime Arbitration Association, a member of the Singapore Chamber of Maritime Arbitrators, as well as a member of the Chartered Institute of Arbitrators here in London. So, Karina, thank you for being with us.
Thank you for having me.
Of course. If you don't mind, let's get started. Straight away, I was wondering if you could briefly explain the function and role of ADR in maritime dispute resolution, and also maybe add on some current challenges to the industry as we go forward.
Historically, it's quite interesting. Historically, ADR, and especially arbitration, is the preferred method to solve disputes. And that has historically been the case already since they had the London coffee houses, so to speak, where ship owners were still the captains of their ships in the 16th and 1700s. And they always tried to solve disputes with peers as experts to decide the issues for them. And that later on turned into the Baltic Exchange. By the way, I'm also a member of the Baltic Exchange since 25 years now, or over 25 years. And so that peers would actually understand the matter and solve the dispute. That has also taken place in the 1950s and 60s at the Baltic Exchange as well. And thereafter, it is taken. The LMAA was established shortly thereafter because there is such a great need, and that is a very good mixture of experts, former barristers, retired barristers, and also some solicitors. And now it's recently been opened to become maritime arbitrators. But the key there is that we have to really have maritime experience and knowledge. And so historically, all the charter parties, it doesn't matter whether it's container ships, tankers, bulk carriers, etc. They all have a dispute clause and then an arbitration clause. So very few matters would go to court. They would rather be preferred to be solved by arbitration. And in fact, arbitration and not mediation, which is an interesting one, because normally commercial parties like to solve their issues or disputes in a very amicable way. But the arbitration, because of the enforceability of an arbitration award, is key. And that's the case because of the internationality of the shipping market. And of course, when you are asking me what kind of challenges we have now, it's more the question of availability, of finding means to carry on with the dispute. If you need to actually have hearings, 80% of these disputes are solved on documents only. But when we have got hearings, and the LMAA conducts about 100 hearings a year, they were usually face-to-face. And now, of course, they have to be done virtually. And also we had to adapt or see whether we had to adapt the rules and issue guidelines. And because the most of the cases are done by the LMAA, and ad hoc is the key method. So it's not institutional arbitration, but it's ad hoc. And the same is in Singapore. It's ad hoc is the way forward, and that's a very quick solution for disputes.
That's very interesting, Karina. Thank you. And I know that some institutions, for example, the LMAA, are moving towards mediation as a preferred means of...
No, the LMAA, the London Maritime Arbitration Association, is purely an ad hoc arbitration institution that also offers mediation, but there's very few there. If you compare it to the numbers, so per year, the LMAA deals with over 1,700 new cases per year. That is a figure that is the ICC combined with the LCIA and the Stockholm Chamber of Commerce together don't have as many arbitrations per year as the LMAA has. And they're all conducted on ad hoc, as an ad hoc arbitration.
Do you think, following the current pandemic and COVID-19 crisis we have right now, that this is a trend that's going to keep growing, or is it we're going to see a change in this market?
I know we rather see that this is the ad hoc arbitration is right now is definitely the preferred method, so that even institutions like the LCIA or the SCC in Sweden are offering ad hoc arbitration now and trying to create ad hoc rules to be more flexible and more responsive during the pandemic, because the institutional ones take too long, and emergency arbitrations that they otherwise offer don't provide exactly the same as ad hoc arbitration.
Well, if I may just expand on what you just said, talking about the industry, its current and future state, what would you say the current COVID-19 crisis have, as we go forwards, affected maritime dispute resolution? Has it has any effect, or not at all?
Obviously, it is difficult to see exactly the outcome or the effects that we have at the moment. Sort of in April and May, especially in April, we just had to first of all deal with the situation of lockdown, so no face-to-face hearings could take place, but a lot of proceedings wanted to go ahead. So either they tried to delay the hearing to organize virtual hearings, or some of the disputes tried to sort of say, okay, the hearing, we postpone it to when the lockdown is sort of released and eased again. But the problem there is, of course, also that you have got a lot of parties, they're international parties, so they would have to travel to London. They would have to deal with the 14 days quarantine now. The same with the expert witnesses. You have the experts sometimes that have to travel anywhere. And of course, the question is now, will this be necessary when we come out of the lockdown? Or whether we will continue to have sort of a kind of now then a hybrid version of hearings, that perhaps counsel and arbitrators are still in the room face to face, but parties, expert witnesses and witnesses of fact might just be brought in via video, for example, because people are getting more experience of cross-examining witnesses by video. And before, everybody was very reluctant, and now everybody says, oh, we have to do it, so we have to get on with it. And all of a sudden they realize it's not actually that bad. It actually has some advantages as well. So traveling is a restriction right now that I guess will not be a restriction later. However, the travel costs will then be an issue, and therefore it's going to be a hybrid version probably.
No, that's very interesting, because I know we've been talking about this in the institute, and I know it's a matter of legal dispute as well currently in the parliament, with the FDA talks with Europe, having professionals coming and going. Do you think that these changes will become permanent, or will it be, as you were saying previously, more of a transitional thing as we kind of move out of the COVID-19 proper and into something else?
In terms of witnesses, I suspect it has to be a very special case where you have to fly them in now, and that you incur that the parties incur the travel costs. Whereas I guess counsel and arbitrators you will still probably see in a face-to-face hearing. But again, we mustn't forget that this is just related to cases that involve a hearing, which are only 20% of the cases. But what I find very interesting right now under the global crisis is also that you don't have to, wherever you are and wherever the parties are, they don't have to choose, for example, a local counsel or local legal representation or local arbitrators. You can choose an arbitrator wherever they are in the world, because you don't have to fly them anywhere. So people can identify and choose exactly the right person they want on their case. And that is what I find fascinating, that all of a sudden it's open to anybody. I reckon, though, at the moment what we are seeing or what we are noticing very slowly is But London, because it has also responded so quickly towards the COVID-19 situation, and it is shown again thriving under crisis with the flexibility, that people are probably even more drawn now to dispute resolution in London rather than in Singapore or in New York.
That's very interesting, Karina. Thank you. If I just might expand on that, as you said, maritime law and joint dispute resolution practices is truly a global business. And I was just thinking about if we can now go even more remote and work with arbitration specialists from all over the globe. What kind of advice would you have for, let's say, UK-based ADR specialists when they now might take on work from countries or regions they never practiced in before, especially maybe in the APAC region or Singapore, which is a big hub already?
First of all, maritime disputes, or let's say charter parties especially, and a lot of new building contracts are based on English law. So they could say it could be under SCMA rules, so it's under Singapore Chamber of Maritime Association rules, and but it's English law, for example. So you have the procedure rules, Singaporean rules, but it's nevertheless English law. So you have to, for everybody else, have a very good knowledge of the English law and the Arbitration Act 1996. And then just be very familiar with the procedure rules, depending on what the charter party or the dispute clause, the arbitration clause dictates. That's, I think, is the key here. And because, as I say, we are all very used to international parties. We are used to international legal representation, and it is and the preferred law is English law.
If that's if the increased globalization of the business will be the upside of this, would you have any words warning or caution to those who now attempt to practice or bring their practice on a more global scale? Is there anything they should be aware of when expanding and working with colleagues overseas?
No, I think it's just being open and having their expertise, I guess, or their unique selling point, so to speak. Because I'm sure a lot of them are quite familiar with English law, or at least common law. And obviously Singapore is a common law based legal system, for example, as well, same as Hong Kong. And so they are familiar with how English law basically works. It's obviously slightly different ruling if you have Singapore law or you've got Hong Kong law or English law, but the differences, if they know the differences, and otherwise, no, it's literally just network with your colleagues, make yourself known, and show that you have the maritime knowledge that's required for any specific case, for example.
Excellent. I'm sure happy to hear that. Talking about working overseas and working in kind of new theaters as opposed to before the crisis here, the Corona crisis, it's no secret to most that the APAC region is awash with conflicting claims of territory and sovereignty. And looking at past cases that's gone to tribunal, would you say that ADR providers in these times of increased political tensions, especially in the South China Sea, might be heading towards a future where they will be forced to consider working with more complex and more cross-disciplinary issues than they've been doing in the past?
That's a very interesting question. First of all, I think we need to make a distinction whether it's a political issue. Is it just a geographical issue, or is it a commercial issue? And then you have to distinguish again on the commercial issues. As I say, if it is a usual contract of transportation, i.e. a charter party, it's usually English law. So you're based on English law. So it doesn't necessarily make a big difference in what region you are from that point of view. If it is, for example, a container trade, and if you have like a bill of lading and you are looking at dealing with forwarders as contracting parties rather, for example, because the trade between China and Philippines, for example, is rather a container trade. and that's the majority of the goods are actually carried in containers. There it depends on what kind of contracts the liners have with the forwarders. But from it's sort of the bigger bulk trade, any commodity trade otherwise that is carried in bulk, you have charter parties, and that's based on English law. So from the commercial point of view, it's not going to make such a difference, because we are happily carrying on trading, and the countries are happily carrying the commodities. For example, between Australia and China is a huge export from iron ore into China, for example. And that just carries on as normal. As I say, it's more than probably on the container side that would have a different impact. And from a political one, I guess in terms of what kind of dispute resolution they would choose, I guess they would rather do a look at either the ICC, for example, or they go to The Hague and go to the international courts, I suppose. But in terms of arbitration, I think, because it's the beauty of arbitration is the confidentiality. So people that have not used arbitration before might prefer this now, because they'd rather keep it under wraps and that it's not public knowledge, like in a court case.
And building on this, thank you. This is extremely interesting, and I think it's a urgent question. If we were to see a major maritime dispute in the region, how would the disruption of trade impact the ADR community?
That depends whether they've got any sanctions on them. It is literally just stopped by sanctions. So if you would have sanctions trading between Philippines and China, for example, yes, that would impact it. Or the impact, I think, at the moment is more the US and China. So one would have to look at the disputes there. And obviously, people are very cautious in the maritime world to trade with China, for example, between the US and China, because of the current sanctions they are. So yes, that would stop probably the trade there for a while, but they would then just find other routes to export to or to import to. So it's not going to stop the maritime world trading, but it just evolves to different routes.
If we were to see again a conflict following increased tensions in the APEC region, do you think there's a place for ADR practitioners and professionals to actually work with belligerent state actors in addition to commercial actors?
I don't think I'm really in a position to answer that question too well. As I say, it's a question of if they prefer confidentiality or not. And if so, then yes, they would probably choose arbitration. They would probably not choose now between, as I say, on a political basis, maybe they would choose mediation. But that is a level I'm not really maritime arbitrators rarely deal with. It's then you have more specialist arbitrators dealing with political and geographical territorial issues, I guess, rather than on the maritime side.
Thank you so much. I appreciate I appreciate the answer. I know this is an extremely interesting but really hard question to answer. But looking ahead for the industry, I was wondering, do you have any projections, predictions, or ideas as to where the maritime field for ADR might be heading next? And do you have any insights or facts that might be especially interesting to the audience listening into this?
Well, in terms of sort of preferred law, it's probably English. I know we are both based here in London, and we're sitting in England. Obviously, we're slightly biased, but nevertheless, because the certainty of the law, the commercial certainty for companies is vital. It's key in the international trade. So they would probably continue to prefer that, and that will be the preferred choice. And in terms of arbitration, I would probably think that maybe there could be a trend that you see large commodity contracts, so not necessarily shipping contracts, but the actual commodity export contracts, also go more towards arbitration. I would reckon that's going to be the case, and they want fast resolve of the dispute. They really, and that's why I think institutions have they have to really position themselves and advertise that they can solve disputes very quickly as well. But ad hoc arbitration, again, I think is the trend, definitely the trend. So Singapore might get a little bit more attention there as well, because they also offer the ad hoc arbitration. But generally speaking, you would see London ad hoc arbitration is the flavor of the next coming 2-3 coming years at least, I would think. And in terms of, I'm so sorry, but also in terms of how disputes will be resolved, I think that will probably be, as I've mentioned earlier already, like a hybrid version. So first of all, you have perhaps no hard copies anymore, but people getting more and more used to soft copies now, because big bundles, and I mean, we have the disputes, you have like thousands and thousands of pages of submissions and supporting documents. So that is all transitioning already strongly now, and sped up by COVID-19, or going to soft copies. Traveling, as I say, is an issue that now you have to more justify travel costs rather than before you had to justify not to travel. So that's the other thing, and therefore it can also probably be streamlining the process and also speeding it up.
Thank you so much, and thank you for shedding light on this this line of ADR in this business, which is extremely interesting, especially now. I want to thank everyone who's been tuning into this and listening, and thank you, Karina, for coming here and answering my questions.
No, thank you very much indeed. I enjoyed your questions very much. Thank you.
Thank you.